The Miss Saigon one.
Oh, absolutely. He's great.
Yeah.
Yeah. Okay, we're ready?
We're rolling.
Okay, so just a reminder again to, if you could incorporate the question in your answer. And so you want to say your name first and how you'd like to be identified on screen.
I'm Jim Ellis. I am a professor at the University of New Mexico School of Law, Professor Emeritus. I've been involved in disability work for a very long time.
Okay, and do you want James Ellis
On the screen, yeah, might help people look stuff up.
Okay.
Yeah.
And you have an initial? You use
James W.
James W. Okay. All right. So could you first just talk about what you knew about Jerome Bowden, how you heard about him?
Yes. By way of background, I'd been working with colleagues on the problems of people with, and I will use the term mental retardation because it was then the term, people with mental retardation in the criminal justice system. And we had spent 4 years with the American Bar Association developing the American Bar Association standards for criminal justice and people with mental disabilities. A year or so after that was done, I was teaching with Ruth Lucassen for the University of Northern Colorado in one of these remote Colorado towns where they do their summer teaching. And I found in the Rocky Mountain News a story that said that a man in Georgia had just received a clemency, a stay of execution in his case because he might have mental retardation. And it became newsworthy. It made a 2-paragraph story in the Rocky Mountain News because as they said, this is one of these rare occasions when a petition for a stay was joined by the Pope and heavy metal rock bands. And that made it into the Rocky Mountain News. And I said at the time, well, when we get back to Albuquerque, we ought to look this up. And a few days later, before we got back to Albuquerque, there was another story in the Rocky Mountain News that they had determined that he had mental retardation, but he wasn't retarded enough based on whatever. And so they'd executed him. During the years we were working on the criminal justice system and mental retardation through our professional organizations and the ABA, the death penalty had not come up. And so we'd written tons of things and had worked with experts on lots and lots of cases, but the death penalty wasn't an issue until the late 1980s. And what crystallized it was Jerome Bowden's case in Georgia.
And then, when Jerome had his trial and he was put on the stand, and could you talk about the fact that of how, I don't want to ask you to talk about something you didn't know firsthand, so, because I know you don't do that, but could you, with regard to the Bowden case and others, could you talk about how stereotypes about people with low IQs get in the way of saving their lives?
Well, Jerome Bowden's case, in a way, exemplifies one of the main problems for people with intellectual disability, which is people have a mental vision or an impression, stereotype, of what people with mental retardation or intellectual disability must be like. And if they find something that seems incompatible with that, that stereotype might be that they have a visible feature like Down syndrome, and since this defendant in whatever case doesn't look like that, or that someone who had mental retardation would never have a girlfriend or would never have found a job. And so those stereotypes become a major obstacle to determining whether someone has intellectual disability, and thus ultimately to the question of whether or not they can be executed.
So, Jerome Bowden's defense attorney was told you cannot mention his IQ, and so how do you think these stereotypes could affect the jury?
Well, the stereotypes before a jury which has been selected to exclude people who oppose the death penalty, for example, but a jury seeing this defendant, watching his reaction to the testimony about the crime, maybe watching to see, is there something here that indicates something about him, just demeanor. And one of the things that they will often see with someone with mental retardation is that they're inattentive. They're counting the dots on the ceiling tile or something because they don't understand the words that are being said. But that may convey to the jury, this is a heartless person, this is a callous person, and thus it doesn't fit with what they anticipate someone with intellectual disability looks like, behaves like, reacts. So that creates a substantial difficulty for lawyers in cases now when they're allowed and required under ethical constraints to raise real issues, of which intellectual disability may be one, depending on the characteristics of their client. Part of the difficulty is the resistance that may come from jurors who think to themselves, I know what mental retardation looks like, and this isn't that guy.
We found two of the people who served on the jury in the Bowden trial,
Yes.
white men,
Mm-hmm.
and they both said if they had known that he had such a low IQ, they never would have voted for the death penalty.
Yeah.
Because can you, are you comfortable saying anything about how his testimony was?
I don't know enough about his testimony to.
That's fine. So after Jerome was executed, can you talk about what the Georgia legislature did?
Yes. Once Mr. Bowden had been executed, there was a move in Georgia led by the group now called the ARC. I think it was then called the Association of Retarded Citizens for Retarded Citizens of Georgia, that this couldn't be right, and that we had to have a law that would make sure it didn't happen again. And through the extraordinary efforts of people with the ARC of Georgia, and in particular parents of individuals with mental retardation, as the term then was, to get that law. And after considerable effort, that Georgia passed that law. Shortly after Georgia passed that law, during the time that Georgia was considering that law, those of us in the disability community and our own professional and volunteer organizations worked to set up standards in which professional organizations, the American Association on Mental Retardation, the American Bar Association, the National ARC, would say it's unacceptable to execute people with mental retardation. They should be exempt from the death penalty. And those movements gained momentum, largely because people had learned from the Georgia case that this was a real possibility.
And could you tell what you said to me on the phone about the parents who fought for those changes in the law didn't have a personal stake in it?
Yes, what we discovered about the parents and about their involvement in legislation, not just in Georgia, but in all of the 18 states that passed statutes before the Supreme Court acted, is that the momentum came from the parents of people with mental retardation, largely through associations now known as the ARC. And these parents, in my experience, never had their kids involved in the criminal justice system, but they knew the functioning of their own child and other people with mental retardation. And the idea that the state could execute someone at that level of disability led them in state after state at considerable cost to seek legislation in their state, saying, well, maybe Georgia does this, but we won't. Or maybe Georgia did this before their statute. We can't let it happen in this state. And those parents whose diligence and commitment to this issue were really extraordinary, those parents were giving up something because everybody in the political field has finite political capital. efforts that you put into one thing can't be spent on something else. And so these parents not only were supporting people who weren't their kid, but were also taking away essentially support, effort that could have been spent on special education or on guardianship or other things that might have helped their son or daughter directly. And they did so because they knew that it was morally wrong to kill someone at that level of functioning. And in state after state, starting in 1989, states followed Georgia's lead. They passed statutes very different than Georgia's, but they followed Georgia's lead in saying, in our state, we won't allow the execution of someone with mental retardation. And the accumulation of those states over the following dozen years are what led ultimately the Supreme Court to revisit the question of whether someone with intellectual disability could be executed.
And so,
Maybe I should add one other thing, and you can then decide whether you want to include it.
Henry?
Yeah. After the first state, Georgia, had passed a statute, the Supreme Court of the United States had a petition, a request, will you please hear our case? And that case had asked, out of Texas, whether someone who had mental retardation could be executed. And the Supreme Court agreed to hear that case and said, well, we'll resolve that question. The question presented by the brief before the Supreme Court didn't say mental retardation. It said mental age of 8. And so when we got involved in the case, the first thing we had to do was to say that's probably not the best way to think about this, that it's better to focus on the category of intellectual disability rather than the sort of rough, backhanded equation of adults with intellectual disability with children. They granted that case. When they granted it, there was only one state. During the time they were considering it, there was another. Maryland was the second state. And what the Supreme Court, Justice O'Connor writing for the court, said, well, we're not ready to say that you can't execute people with mental retardation. They're saying you can't execute this individual because there was unfairness in his trial and his jury didn't have an opportunity to decide what the impact of his intellectual disability should be on his case. But the court said we're not at a point at which we can say that the Constitution, the Eighth Amendment to the Constitution, prohibits anyone with mental retardation from being executed. And then in what may have been just a brief line in the opinion, Justice O'Connor said, looking for a national consensus on a question of punishment is something in which we don't look at the opinions of professional organizations, of which they had a number in this case, and we don't look to public opinion polling, which was already very strong on this. They said, we look to see what has happened in state legislatures. And at the time they wrote it, they said there's only one state that's passed a statute. They amended that because Maryland had acted it. So you've only got 2 states. And we took that to mean that if you had more states, maybe we would reconsider. And starting then, we went from state to state under the leadership of the ARCs, and in particular the ARCs of the states, and met with them under their leadership with their legislators explaining what mental retardation or intellectual disability meant. And in 1990, for example, we got Kentucky and then Tennessee in short order. And we got about one more a year throughout that decade, to the point that when the Supreme Court took the case the second time, there were 18 states that had passed such laws. And ultimately, in that case, the court said, well, 18 states does indicate a national consensus.
So, so that was then the Atkins case?
Yes.
So could you, let's talk about Darrell Atkins. Just anything you know about his life before the crime, if you know anything, and if not, just about the crime and what had happened in the justice system?
Darrell Atkins was and is a person with intellectual disability. And like so many people with intellectual disability, he survived sort of on the fringes or in the shadows of society, and he would occasionally have a job and other things that might not fit with people's stereotype of mental retardation. He ended up in a crime in which someone who was not disabled, and he committed a robbery in which someone was killed. He was sentenced to death. And the question in his case ultimately became whether there was now a consensus of the American people that executing people with intellectual disability was unacceptable. So his case became that case. And when the Supreme Court had originally taken the case, it wasn't Darrell's case and it wasn't Virginia. It was in North Carolina. And so everyone was ready. We started briefing the North Carolina case. And then the North Carolina legislature passed a bill that prohibited the execution of people with mental retardation. So we suddenly had a case that was moot, that no longer presented the issue. And so the question then was whether the court would take another case. And they did, and they issued an order that said those of us who had briefed as friends of the court in the earlier case, the McCarver case out of North Carolina, that those briefs would be treated as briefs in Darrell Atkins' case. And then the parties briefed Atkins after the Supreme Court had granted cert in it.
So between the time of the Henry Supreme Court decision and the time that you put first the North Carolina case and then the Atkins case before the Supreme Court, was there discussion about, so when do we go back to the Supreme Court? How many states do we have to get?
I'm sure that people who were in the Capital Defense Bar had conversations about that. The main effort, though, in those cases was now that the Texas case had said you can't exclude evidence of intellectual disability, was how best to present evidence of intellectual disability with regard to those clients. And in addition to working with state legislatures, we also worked with lawyers to help them understand enough about intellectual disability that they could make their case. And the lawyers and the mitigation specialists who worked with them were the people who really kept this alive in the courts, and sometimes were successful and sometimes were not. They could not say in their case that the Supreme Court has said you can never execute anyone with intellectual disability, which they can now say. But until the Supreme Court made that judgment in 2002, they had to instead say that the disability of my client was such that his level of culpability, his responsibility for his act, while enough to punish him, isn't enough to support execution.
I want to stop a second.
Sure.
A bit better, yeah.
Is that better? Okay, all right, good. So, so where were we? So we were talking about Mr. Atkins and the history of his case.
Yes. The case against Mr. Atkins, as with so many of these cases, focused on people's stereotypes about what mental retardation or intellectual disability meant. And so the focus was on, well, there's no prohibition on executing someone with intellectual disability in Virginia law, but you shouldn't even consider it to be a mitigating circumstance because he doesn't really have that disability. And again, the focus was on, well, here's what people with mental retardation must be like, and here's what their lives must be like. And that did not have much relationship to the reality. But Mr. Atkins' case also revealed something else about public reactions and expectations of people with mental retardation or intellectual disability. Often these individuals have figured out, facing discrimination and all sorts of negative things in their lives, that they have figured out ways to mask their disability and to appear to be more capable than in fact they are. And this concept, which is called the cloak of competence, trying to appear more disabled, was very much what was part of Mr. Atkins' case, is that he could pass for someone without disability in a way that might have helped him earlier in his life, being able to get a room in a rooming house or to do dishes at Denny's, but that was working to his major disadvantage as he was facing the death penalty. And another feature in many of these cases is these guys who are very limited, having found something that was successful earlier in their life, don't let go of it so easily, and continue to maintain an appearance that they hope will lead people to think that they're more able than they are, or that they're smarter than they are.
Okay, so can you describe your situation at the time of the Atkins case, how you got involved in it, and whether you've been before the Supreme Court before?
In terms of my own involvement, I had briefed cases to the Supreme Court of the United States, including Johnny Penry's case out of Texas. I had been involved in litigation dating back to the 1970s involving people with disabilities, had been filing briefs for those disability organizations since about 1984, but had not argued those cases. I'd been presenting, I'd worked with lawyers on their party, the briefs for the party, but mostly represented the disability organizations, professional organizations and voluntary organizations like the ARC, in helping to explain things about disability, mental health and mental retardation to the Supreme Court. I had not argued before them and never thought in particular that I would, but was asked when the court had granted the petition to hear Darrell Atkins' case. I was asked whether I would brief and argue the case for him, and out of candor, my response to them was that I had not argued in that court before, and in fact had not argued, I think I said, a traffic ticket in police court, and nonetheless, they asked me, because of my background in on that issue and my advocacy before that court on other disability issues, they asked me to argue the case, which I was glad to do.
Who were the they that you talked about?
Largely lawyers who were already representing Darrell Atkins in Virginia, but also other people in the capital defense community.
So can you describe the scene when you're going up to the Supreme Court? Were there demonstrators either on either side? How did you feel going in there?
I had, first by way of preparation, particularly for someone as inexperienced as I was, you do a lot of practice arguments. There are now arguments that take institutes that do these practice arguments at Georgetown and other places, and I did those. The ones that were most helpful to me in getting me to do it better, and I've been in that court probably more than 100 cases. I've heard arguments a lot. But the practice that was most helpful was my colleagues at the University of New Mexico, who would time after time, day after day, get me to go through arguments on video and yell at me after each of them. No, that answer needs to be shorter. And they correctly helped me move away from the way you would explain something in a classroom to the way you would explain something under fire in the Supreme Court of the United States. So they were immensely helpful to me, but other people who were experienced Supreme Court litigators were helpful as well. But as I say, I had been to well over 100 arguments in my capacity as a constitutional law teacher. And so I had a sense of how that worked. It's obviously different when you're the one behind the lectern. But so I had some experience with that, but I had immense help from lawyers and my colleagues in figuring out how to make the argument.
So how did you feel when you actually got there, when you're just getting ready to do the argument?
You're obviously nervous on an occasion like that. I knew my way into the building. I knew which exit and entrance you used. So it wasn't so much that. And I knew where the room was, where you wait as you're going to go in to the argument. But it is, for a moment, a little intimidating to be before those justices and having them ask questions of you. But that dissipates very, very quickly, and you engage in a dialogue with those justices and answer questions for them and respond to concerns that they raise. And most of the members of the court had questions for me. I haven't done a count, but I would imagine Justice Scalia had certainly the most pointed questions. And trying to present the case as clearly as I could on the basis of what intellectual disability meant, and why it so reduced the culpability of an individual with that disability that executing him would violate our Constitution, as the court ultimately held.
Do you remember what kinds of things Justice Scalia was asking or saying? 'Cause I know he had real concerns.
He did have real concerns.
Sorry, I need to start with Justice Scalia.
Yes, Justice Scalia asked many of the early questions and presented a skeptical question that was helpful in getting the focus on why it might be that the court might conclude not to provide protection for people with intellectual disability. So his questions sort of shaped the argument. But Justice Kennedy's questions and Justice Ginsburg's questions, Justice Stevens' questions, then brought it back to what the relationship was between intellectual disability and other conditions that might come up in capital cases. So it wasn't that Justice Scalia dominated the argument, but his early questions were helpful in directing the attention of the court to what the issues were.
And what were his concerns or his objections?
His concerns had to some extent to do with the nature of mental retardation and whether everyone who had mental retardation had limitations that made their execution impermissible, made it unlawful. And so he was focusing more on the uniformity of the group and the shared characteristic of people with mental retardation and intellectual disability. And then the further legal questions were pursued by other justices as well.
Why did he care if people with mental retardation were all the same or not?
I think Justice Scalia started with a skepticism about categorical protections from the death penalty as a general matter. I don't think that it had so much to do with intellectual disability for him as a concern about the death penalty and whether states were free to operate it. That concern, as I say, led to a more general discussion with his colleagues about a number of the issues involved. And happily, we had briefed the case essentially twice. We had briefed the case when it was a North Carolina case for the National Disability Organizations, American Association on Mental Retardation, and the ARC. And then we had done a second brief when I was asked to represent Darrell Atkins. We did a brief for the party. It was the brief for the professional and voluntary organizations that seemed to be the focus of their questions. And the court, of course, knew that I had been counsel of record for that brief, and their questions tended to focus more on that than on the particulars of Darrell Atkins' case. The members of the court knew that while they were addressing the case of one defendant in one state, that they were being asked to make a ruling for the country. And so it quite quickly focused into more generalized questions of whether states which had not yet, like 18 of the other states, that had not yet passed statutes, whether they too would be prohibited from executing people with mental retardation. So the question was much less about Mr. Atkins and much more about the characteristics of people with intellectual disability.
Thank you. Am I correct that Justice Scalia also was concerned about the floodgates and about malingering? If you could address those.
Justice Scalia addressed both of those concerns, but they had been part of the discussion in the state legislatures as well. In particular, a concern was that if the court ruled in favor of Mr. Atkins, that suddenly everyone on death row or everyone facing a capital charge would successfully claim to have intellectual disability. We tried to make the case that the diagnostic process would not support that. We did not then know, but we now know that that proved to be fully true, and that the incidence of successful claims of intellectual disability under the Atkins case were roughly proportional to the incidence of disability among people more generally. But there was concern about that, and that in turn led to a concern that if we do this, the exception will swallow the whole, and that the death penalty will now become solely focused on exceptions. That again did not prove to be true. Shortly after, within a few years after the court's ruling in Atkins with regard to people with intellectual disability, the court faced a parallel, in some ways, question about whether young people, in particular people under the age of 18, should be exempted from the death penalty. And relying to some extent on the court's opinion in Atkins, the court decided that they too would be exempt from the death penalty, that the attributes of their immaturity were such that death was a penalty that was not appropriate for their level of culpability.
And could you talk about Justice Scalia's concern about people pretending to have, you sort of did, but just explicitly.
Yeah. Justice Scalia raised a concern, and it was a concern we'd heard in many of the states as we went into the state legislatures, that anybody could pretend that they had mental retardation and could fake that disability by intentionally scoring low on IQ tests. As it turns out, that is not possible. That finding malingering, which is the term employed on that, of people claiming to have intellectual disability, but who do not, and who are just coming up with it as an argument, that has not proven to be a major problem in the courts in implementing the Atkins case. There is also in the definition of intellectual disability a requirement that the disability have begun in childhood, either at birth or in the early years of life. And so someone to fake mental retardation would not only have to be very smart to figure out what questions to answer wrongly in an IQ test, he would also have had to start that process when he was in elementary school. So I understand the concern. I don't mean to make fun of the concern about malingering, but it has not proven to be a problem. And our understanding of, in the professional community, of what intellectual disability meant was pretty clear to us that it was not going to be a major concern, that people were not going to be able to falsely claim late in the day that they had mental retardation. Individual cases have to be litigated out, but malingering has not been a major problem.
And could you talk about, you met Daryl Atkins one time. Could you talk about what he's like and how it felt interacting with him?
I did. After I was asked to argue the case for Mr. Atkins, I went to Virginia to death row, and in the company of the people who had represented him below and to whom all credit goes for having managed his case so well that it could in fact turn out as it ultimately did. And they arranged for me in their company to meet him and to talk with him. And I did. He was not reluctant to talk to me, or even didn't bristle so much at the idea of mental retardation. Many defendants do. But he couldn't let go of his practice of trying to appear smarter than he was. And he would use words that seemed uncharacteristic of someone with disability. A number of people with intellectual disability find a method of trying to pass for non-disabled. The term often used is the cloak of competence, trying to appear less disabled than they are. And in his case, vocabulary was one of the tools that he had used and that he continued to use in meeting with me. When you pressed him further and asked him questions that couldn't be answered with a simple one-word answer, when I asked him, how would I get to this prison from Richmond, where I had come, he was unable to even address it because that wasn't one of the things that he'd sort of memorized.
Could you just give an example of a kind of vocabulary thing that he did?
Daryl Atkins used words of several syllables when the occasion didn't require them, and often he would use words in ways that were close but not quite. He continued to discuss what was lethal injection, which was the method of execution in Virginia, and he talked about it quite a bit, but he kept calling it legal injection because that sort of rhymed, and he had associated that as the way he could talk about it and appear to be more understanding and more sophisticated than in fact he was. That happens quite a bit in my experience with individuals with intellectual disability, certainly in the criminal justice system. Not only do they try to hide their disability from people they encounter in ordinary life, they also continue to try to hide their disability from their own lawyers, when the impact of that disability wouldn't be to harm them, but would in fact work to their advantage, not just in the death penalty, but on questions of competence to stand trial, trying to appear that you understand stuff that you do not, is a very common characteristic that we have encountered in these cases. It works very much to the disadvantage of the people involved. It works to the disadvantage of the criminal justice system, which assumes that these individuals understand things about the case that they do not understand. One of the things that came out of Atkins, having nothing to do with the death penalty, is that lawyers who had clients in non-capital cases and capital cases would come up to us after this, we were doing training after Atkins, and would come and say, you know, I now understand that this client I had some years ago, now I've figured it out. He was trying to appear smarter than he was, and I missed it.
So sad. Could you say anything about Daryl Atkins' personality and whether you felt you were able to connect with him?
I don't have enough.
Okay, all right. Okay, just back for one moment to when you get to the Supreme Court for that case. Were there people demonstrating on either side out in front?
There were people who had come. It was not one of these occasions when you see substantial crowds of people demonstrating. We've had that in other cases involving disability. This was not one of those. We had people who were interested, people from the Congress who were concerned about disability. Senator Kennedy was one of the first people to speak with me after the argument. There were and members of his family. There were people from the disability community who were very concerned about this and who came to the argument. We were able to get a few of our law students who had worked on the brief. And one of the things that we do representing these disability organizations is we use teams of law students from the University of New Mexico who do the research and who do the editing and who help us find, we need a source about this. We were able to get a few of those students to come hear the argument, and they got to hear questions that were based on something that they had found in the literature. And it's always wonderful when that happens, and we've done that probably 20 times over the years. And it's one of the things that our students at the University of New Mexico have an opportunity to work on cases that matter in the way that the death penalty cases obviously matter. And they perform a wonderful service for us in doing this work. They don't get credit for it, but they volunteer to do it, and they do it very, very well.
Okay, thank you. Okay, let's see. Oh, could you say what's happened to Daryl Atkins since then, where he is now?
I don't know enough to be helpful. Daryl Atkins is no longer on death row. The issue that won him release from death row was not directly related to his disability. There were other problems with the prosecution of his case, and one of those led to the judgment that he be released from death row and return to the prison population.
So could you explain how, given that the Supreme Court decided his case in his favor, how come he wasn't then taken off death row?
Because one of the things that happens in the Supreme Court is, with very rare exceptions, when they reach a judgment that suggests that what had happened before violated the Constitution or was unlawful in some way, they will remand the case or send the case back to the court below. And here they sent Mr. Atkins' case back to the Virginia courts, where that issue was litigated and other issues were litigated, and it was one of the other issues that ended up disposing of the prospect of his receiving the death penalty.
So could you say...
And let me just say to you Rob Lee can help you with that. An easy to remember name in Virginia, Robert E. Lee, was his lawyer and knows this stuff backwards and forwards, and I do not.
Okay. Do you recall what Daryl Atkins' IQ was?
I don't.
Okay. And just Robert Lee.
And Rob can also lead, can give you the names of other people who worked on the case, who worked much more directly with Daryl, obviously, than I did.
So
they're the source.
You don't know why, when it was remanded, they didn't say, hey, well, the Supreme Court decided and you have retardation and so
I have impressions of that, but only that.
Okay, all right, that's fine. Could you give your excuse me, your opinion about why, in light of the Atkins decision, why people with intellectual disabilities are still being executed. Why and or how?
There are a number of reasons. One is that
Could you
I'm sorry. Oh,
include
yes.
the
I'm sorry.
question?
Yes,
Yeah,
right.
that's it.
One of the problems in the implementation of the Atkins case, the reason that there continue to be death penalty cases involving people with intellectual disability, is because prosecutors and courts continue to cling to stereotypes about people with intellectual disability and want to evaluate the condition of a defendant as compared to the image they have of what someone with intellectual disability must look like, what their life must have been like. And that has made it a challenge in a few jurisdictions to continue to have a fair adjudication of whether someone has intellectual disability. The number one state in which that has proven problematic is the state of Texas, because Texas adopted, shortly after the Atkins decision, a set of rules about determining whether someone had mental retardation. It was called the Briseno factors, and they made these up. These were not based on the literature. They were not based on the experience of people who work with individuals with intellectual disability. They instead focus on what are imagined to be the characteristics of people with disability. Well, if you ever held a job, you must not be able to have mental retardation. Or if you had a girlfriend, or fill in any number of other characteristics that Texas chose and told its trial courts, the Texas Court of Criminal Appeals told trial courts in Texas, this is what you need to use in deciding whether someone is entitled to Atkins relief. And the Supreme Court of the United States now twice has told Texas that they cannot use those factors. In the first case involving a Mr. Hall, the court said quite clearly those are not factors that are based on science, and you are required to use factors based on science. Mr. Hall's case went back down. He was sentenced to death again, and the case went up a second time with the courts in Texas saying, we're not using those factors anymore, but we're using things that are very much like them. And in an unusual case, the Supreme Court of the United States remanded again and essentially said, no, you have to follow the science.
So what happened with Mr. Hall?
I'm not sure. I'm almost certain that he has life, but I don't rely on me. And Delpha knows. And Delpha knows.
Okay, all right. Could you talk about? Do you have any sense of in how many states or how many people are still on death row who have intellectual disabilities and who are in danger of being executed now?
It is quite clear that this problem has not gone away in the years since Atkins. Substantial numbers, maybe the majority of cases, get resolved satisfactorily with care below, including agreements by prosecutors when they review the evidence that this is someone for whom the death penalty is unavailable. But there remain cases in which that is not true, and in which either cases of people who were sentenced to death before the Atkins decision in 2002 and whose cases are still being litigated, and some cases that were litigated subsequent to Atkins, in which judgments largely based on stereotypes and other non-scientific factors led to the death sentence of individuals who were clearly entitled to Atkins relief. And so it remains an area of litigation, both in the courts below and in appellate courts, as to how those courts are supposed to make a resolution. And the Supreme Court of the United States, in a case out of Florida, came up with the memorable line, having said that the state of Florida could no longer use an arbitrary hard ceiling of an IQ score to deny people Atkins relief, said intellectual disability is a condition, it is not a number. And their focus on the characteristics of the person's life rather than the happenstance of what a single IQ score might have been, particularly on a test that might not bear inspection in terms of how it was administered. That was an important message to lower courts that they're supposed to take seriously the science and the reality of lives of people with intellectual disability.
Now, I don't want to ask you a leading question or
What you got?
anything, but could you address the role of psychologists in getting these executions continued?
Related to it. One of the things that we've discovered, starting before Atkins, when intellectual disability first became a widely recognized issue at the time of the Penry decision in 1989, but particularly after Atkins, is that there is a need for mental disability professionals to do evaluations to help the courts make a judgment about the situation and the condition and the functioning of someone for whom an Atkins claim has been made. And so those individuals, some of whom are psychologists, a few of whom are psychiatrists, there will occasionally be an occasion for special education teachers who knew this person when he was in school. Those people possess knowledge about the functioning of an individual, not just the IQ testing itself, but the functioning of that individual. And in particular, mitigation specialists, people who focus their efforts on trying to understand the course of a defendant's life, often find that there is evidence of intellectual disability, of tests that had been used by psychologists in the past, special education records, even in jurisdictions that said, no, we destroyed our records a long time ago. These are very diligent people, and they often find records that were thought not to exist. And in case after case, those records have demonstrated that this is not, as Justice Scalia had feared, something that was concocted or that came up late in the day, but in fact that had been part of this person's life from the earliest days.
So those are the people who, the psychologists, et cetera, who are helpful. What about the ones who are brought in by the prosecution or the state's attorneys?
In terms of the roles of psychologists and psychiatrists, there are three categories, obviously, of individuals. Those mental health professionals who are employed by the defense, those that are employed by prosecutors to do an evaluation of an individual, and a third category of individuals who have been appointed by the court and who are to report to the court. And it is absolutely clear that the Constitution requires that every defendant who has an Atkins claim is entitled to experts of his own, and that has become an area where psychologists have increasingly done their work. There are also psychologists and psychiatrists and other mental disability professionals who do evaluations for the prosecution and for the court, many of whom are very serious about it and take the concern as a serious matter. And many of those cases end up being transformed from death penalty cases to cases that are not death penalty. There remain some psychologists who continue to use factors that are not based on science, and those cases are the cases that end up going to appellate courts very often. But our concern at in the professional community, and in particular at the University of New Mexico, is providing judges with guidance so that they can make sense of the testimony. And we've just published a long piece which gathers together all the literature on each of the relevant issues about the life of someone and the evaluation of someone with intellectual disability. And our audience isn't the psychologists. Our audience is the courts, so that they can become more sophisticated consumers of information about testing, about life experiences, about a variety of concerns that come up in the life of someone with intellectual disability. And it is our hope that in presenting all sides of the literature, helping them understand what the professional consensus is, that we will have fewer cases that turn on stereotypes and false impressions, and more, whatever the ultimate result, that are based on the reality of what we know about intellectual disability and its evaluation and diagnosis.
Great. Because you know how Jerome got executed, right? This hired gun psychologist.
Yeah.
And then the Warren Hill case.
Which we were involved in
Yeah.
2 or 3 times.
So sad. Okay. Can you talk about, and I'm not a lawyer, so but it struck me that because some of the decision making, the standards are left to the states, that is there an equal protection issue here, or at the very least, could you talk about? I know in Bloom's article he talked about in some states Atkins cases are more likely to be successful, much more likely than in other states.
When the Supreme Court issues a ruling like Atkins, they will typically remand the actual case to the lower courts in that jurisdiction. But they will also often say, as they did in Atkins, that the particular procedures and rules by which Atkins relief will be dealt with in the states should be devised by the states, either by legislation or often by rules of courts. A number of states took that generalized, almost boilerplate, we're sending it back to the states message to mean we can do whatever we want. And the Supreme Court has made clear in the Florida case about IQ testing and in the Texas cases about the Briseno standards that no, this is a national standard, and that states can make their own judgments about whether these issues are decided prior to the trial and before which body. We have some pretty good experience on that, that doing this before the trial not only saves immense resources because capital trials are very expensive to be held against someone who is ineligible for the death penalty, but that it makes a good bit of sense to make that decision before the trial and to do it before a judge. But states differ in the way they've chosen to set that up. But a number of states took this as an invitation, we can shape this any way we want. And the Supreme Court has made pretty clear in recent years that they do not find that an acceptable response to Atkins. And so the states have been told pretty clearly that their standards for Atkins relief need to be consistent with the national understanding and more particularly with scientific understanding of the nature of the disability.
So you think there aren't big differences among the states anymore?
There are substantial differences among the states with regard to procedures. And there are outlier states, the state of Georgia comes to mind, in which the procedures have proven to be very problematic for people seeking to have a fair adjudication of whether they have intellectual disability. In particular, the imposition on defendants of a very heavy burden of persuasion beyond a reasonable doubt. So there are some differences among the states with regard to those procedures. The differences among the states with regard to the science of how do you decide and how do you investigate whether someone has intellectual disability, we can hope will become more and more uniform as the states start to respond to the Florida case and the Texas case, in which they were told by the Supreme Court of the United States, no, you have to follow the science.
And it's my understanding, this is just a very brief answer, I think.
Mhm.
Can you just say, aren't some of the judgments about whether or not someone has an intellectual disability, in some courts they're made by judges and in some by juries? Is that right?
Yes, there are differences among the states with regard to procedures, both when the issue is decided, is it pre-trial, is it during the trial, and whether it is a judgment made by judges or by jurors. For a number of reasons, it has been clear for a long time that the states that can sort this out in the most clear and economical and consistent fashion are the states that turn this question to judges and who do it before the trial. There remain differences on that, but there is a growing consensus that fair adjudication is handled best before the trial and handled before a judge rather than appeals to the prejudices of jurors.
So, do you think there are judges who remain prejudiced and ignore what Supreme Court said?
There remain concerns among defense lawyers about particular judges who may be particularly averse to Atkins claims or skeptical of Atkins claims. But the process the Supreme Court has set out in its recent decisions tells those judges that they can't just make it up, that they have to follow and adhere to and base their judgments on the actual findings in the case and on the science of what intellectual disability means. The challenge to lawyers in the cases below is not a small one, but I think the Supreme Court has given clear indication that those lower courts are supposed to follow national standards.
Do you think there'll have to be a Supreme Court case about the fact that the person can have strengths, and that those strengths don't mean that they don't have an intellectual disability?
One of the issues that has come up most often and that is a principal source of misunderstanding by judges and by jurors is the question of strengths and weaknesses, and the supposition, the impression, the stereotype that if you have intellectual disability, there can't be anything that you are able to do. And one of the things that is clearest from the literature for decades is that for people with intellectual disability in the range that is addressed by criminal courts, people with intellectual disability but who function in society, the clear indication is that for the vast majority of them, their weaknesses, their impairments are accompanied by strengths. And there are some things that they've learned to do. And there are some things that they've managed to do. And one of the things that has been clearest and that was resolved by the Supreme Court of the United States in the Hall case in Texas was that it is a violation of the Eighth Amendment to ignore the scientific understanding that strengths coexist with weaknesses. And it violates the Eighth Amendment to say, well, he can't be mentally retarded because he did this. That is unscientific and outside of our understanding in the scientific community and in the disability community, and that states are no longer free to make that judgment. That is easier to deal with before judges than it is before juries, because the temptation to try to smuggle some of that other evidence in to juries is less tempting when you're before a judge.
Thank you.
Why don't you lean a little bit to your Let me just lean over so you're closer to the lens.
Oh, okay.
Yeah.
Okay, I've been trying to stay
No,
out
you're,
of the,
well, no, you're.
out of the way.
You're quite a distance, so
When-
you can lean over further.
When,
Okay.
when the camera's done, I'll be glad to tell you a Justice Scalia story about legislative history. It doesn't work for this, but
Okay,
yeah.
okay, great. Let's see, so what kind of, and you've sort of talked about this in a way, but I know that the public assumes that it's judges make life and death decisions, but in what you've been talking about, you're talking about the importance of professionals being brought in. Can you address the question of who is really making the determination in the Atkins cases? To what extent is it the psychologist who does the IQ evaluation, and to what extent is it the judge? In other words, is the judge in essence sort of rubber stamping what the psychologist says?
The psychologists who are involved in Atkins cases happen in several ways and come to the case in several ways. One, for those psychologists, however they're involved in the case for the defense or the prosecution, is to do a contemporaneous evaluation. How can we measure this person's functioning now? But there are also pieces of evidence done by psychologists years ago, or by people who were not psychologists, early IQ scores from when the individual was in grade school, educational records that they were determined to have to stay back a year, that they weren't promoted. Those records involved psychologists and others who had no idea that they were involved in a criminal justice case, but whose work needs to be evaluated. The psychologists and psychiatrists and other disability professionals who are working on the case once it is a capital case now have clearer guidance that they're not allowed to, that this is not an occasion in which they can just sort of freelance and make a judgment, well, I think that this is someone for whom the death penalty is appropriate or is not. That the standards imposed by the court and its adoption of professional standards and judgments about intellectual disability means that psychologists for the state, psychologists for the defense, psychologists employed by the courts all have a more common language of what they are supposed to help the courts understand. And that provides an opportunity for all of those psychologists, for whomever they work for, to bring their professional judgment, not professional judgment in here's how I want this case to come out, but professional judgment, this characteristic is common among people with intellectual disability, or this characteristic is not inconsistent with what we know happens in the lives of people with mental disability.
So just to be devil's advocate
Mm-hmm.
for a moment, do we really need the judges if we have a psychologist?
The judges need to make a determination about the law, and the legal question is whether or not this is an individual who is exempt from the death penalty because of his intellectual disability. And the only person who can make that judgment is a judge. But the judge will receive testimony and evidence from mental disability professionals who will tell that judge about testing and about evaluation and about life history and other matters that the judge will have to weigh. Those professionals are now clearly empowered and at the same time directed that they are to follow professional standards rather than freelancing on what they think might usefully be the answer. That their judgment must now be consistent with and conform to the scientific understanding of intellectual disability. And the professionals in the intellectual disability field, the professional organizations, individual scholars, individual clinicians now have a substantial consensus about all or most of the questions involved in intellectual disability. And the U.S. Supreme Court has made clear that those understandings are now the contours of the protection of the Constitution against the death penalty.
So you have confidence in the psychologists, because when I look at the psychologist who tested Jerome Bowden right before his execution, the various professionals in the Warren Hill case, Dr. Death in Texas, and I'm a psychologist, you know, and I'm wondering, do you have confidence that psychologists are not being subjective and biased now?
We have in our relatively recent history examples of mental health professionals who have performed poorly and who have tried to lead courts to judgments that weren't based on the scientific understanding of mental disability, whether in the death penalty context or other contexts. Those rogue positions have become substantially more difficult as the U.S. Supreme Court has made clear that the constitutional standard with regard to the death penalty is the professional consensus with regard to the understanding of what that disability means.
So what do you think, if as long as there continue to be any overly subjective rogue psychologists and judges, who, as Michael Perlin said, you know, most of these judges are former prosecutors, he said, then do you, because one of my questions then was going to be, what's going to stop these executions? And do you think that more Supreme Court cases are going to be needed ultimately, or what's going to stop this?
There's no real way to predict whether this issue will come back or whether some subset of it will come before the Supreme Court of the United States. But the Supreme Court has made sufficiently clear that professional standards must be adhered to. But something else has gone on at the same time, which is that the capital defense bar, lawyers who represent individuals facing the death penalty, are now much more sophisticated and much more capable of cross-examining, of understanding the reports not only made by the experts that they have employed, but the experts employed by the prosecution and by the court. And thus that process, as the criminal defense bar has become more sophisticated, much more sophisticated about disability, has meant that the room for divergence from that professional understanding, it has made that that has made it more and more difficult. And we can hope that as things proceed and as those defense lawyers and those who work with them become more sophisticated about the nature of evaluations, that those improvements will work their way back to the courts.
I love your optimism. I hope you're right. Do you, I've tried to find out from the Death Penalty Information Center and other places if there's any rough estimate of how many people now on death row probably have intellectual disabilities.
Does DPIC have a number that they use? I thought they did not. I'm on their board, but I haven't looked at that piece of it for them.
And Bloom sort of did years ago, but
He did. The other place to look, and I have not, is LDF, the NAACP Legal Defense Fund, which has for a very long time cataloged people on death row. It's called Death Row USA. I don't know whether they look at disability as a separate category, but you might give them a call.
I will. Anybody there in particular?
I'm not sure who would be the best person to talk to.
And I think I just, my only other question is whether there's anything else you want to say about any of this.
Give me a second. I think
That's great.
Sorry about that.
I have no questions.
Okay.
Okay. I think we're through then.
The,
Thank
the
you.
role of parents, yes.
Thank you. Do you need room tone or anything?
Probably would be a good idea, so I'm just gonna turn the camera off for a second.